You're listening to The Brand Compass, conversations to navigate your way to building a brand fit for purpose and poised for success. Here's your host, 𝗘𝗣𝗜𝗦𝗛𝗟𝗟.
Hello there, my friend, and welcome back. It's great to have you with me, and thank you for choosing to listen today. Quite a while back, around episode 20, I brought Stephen Ruse on to come and talk us through all the elements about protecting your intellectual property. As a subject matter expert and a service provider, you'll be well aware that your value is sitting in the work you do, your reputation, and in any proprietary methods or models that you have created. Well, the world is spinning at an alarming rate at the moment, and there is an extra layer that you need to consider when it comes to your intellectual property, and that is artificial intelligence. While there is a lot still developing as we speak, I thought maybe it would be helpful to bring Stephen back on so we can talk a little bit about how AI is impacting how you control the ownership of your intellectual property, and that may also include, although we'll get into that discussion today, any kind of video or avatar likeness of you and even maybe your voice. If you haven't listened to episode 20 yet, I'll reintroduce Stephen for you quickly so you can know a bit about him. Stephen is a senior associate at 𝗘𝗣𝗜𝗦𝗡𝗟𝗟, a legal firm which has 7 offices in the UK and supports clients around the world. His specialism is in intellectual property and IT. He advises his clients on areas like registering and protecting their trademarks, IT and software agreements, and commercializing their IP. Stephen's married to Jodie, still has 2 young children, and lives not far down the road from me in Northampton. Welcome back, Stephen.
Thanks for having me on.
Right, it's really great to have you back on, Stephen, because I actually got quite a bit of good feedback from our last episode and a lot from connections that we both know when we were out networking as well. So there are people listening to us. Yay! We've got a bit of a trickier topic for us to chew on today. I'm sure you will agree, because it feels a little bit like quicksand at the moment, right? And this is this rise of artificial intelligence. Before we dig into the conversation, maybe it might be a bit useful to give a high-level definition of artificial intelligence in terms of what it means for maybe people that actually haven't even stopped to think about it yet.
Yeah, absolutely. I mean, it is a fast-growing area, and it's moving at sort of light speed almost, you think, given that I think it was in the 1950s it was kind of first talked about by Alan Turing. And since then, obviously, not a lot happened right up until your kind of 1990s, and then from there it moved very quickly. But broadly speaking, AI is talking about the ability of computers to sort of take inputted data and think about it in a way that isn't just responsive. So it's the sort of ability to simulate that intelligent behaviour that we have, or certainly hope we have. And it's really that next step from what we've always had, which is computers input X, you get Y, to thinking about what you're asking and giving you an answer. And from there, and I'm not going to pretend to be an expert in how this all works and so on, that's sort of not my field, but as I understand it, there are really 4 stages of AI as it's kind of known at the moment. So the first one you've got is reactive machines, and the good example I was given of that is Deep Blue, I think it was called, the machine by IBM that played chess against a grandmaster in the late 90s and beat them. So that was kind of an early part of AI, and then from there it goes on to sort of limited memory, where it can take in what's going on around it and has recently happened, but it has no long-term recollection. And the example I've always been given of that is self-driving cars. So they know what's just happened, but they don't recall what happened 6 months ago in order to make a decision as to what they're going to do on the road right now. And then there's the third stage, which is subject to some debate, but some people think that's where we are now with sort of ChatGPT, which is called theory of mind.
Okay.
And that's where the program is essentially able to understand that people make decisions based on information, emotion, their feelings, and it kind of builds that into its process. And I have seen some debate over whether that ChatGPT actually does that or doesn't do that, but from what I've been able to discern, a lot of people think we are just about there now.
Is that where the machine learning? Is that where the machine learning comes in? Sorry to interrupt you.
No, that's fine. Yes, I think so. So it's sort of taking all that learned information, which other systems have had before that, but it's able to then understand what you're asking it. So if you ask ChatGPT, I don't know, what is AI? And then you can lead it through other questions. It tries to understand where you're going so it can give you a more accurate answer.
Gotcha. All right.
Yeah. And then the stage 4, which is hopefully quite a long way off, is sort of consciousness or self-awareness. That's pie in the sky stuff right now, but quite scary when you think about where sci-fi has gone with that sort of technology.
Yeah. So the sentient kind of level of where we're trying to work out whether people are robots or not, or
that's it. Your kind of Skynet disaster scenario. Although
lovely.
Yeah.
So I hope that's not in my lifetime. Right. So I think maybe to open up this discussion, I wonder if we can maybe think about two things around ownership of intellectual property. So the first one, and I know you've got a few thoughts on this one, is people are using tools like Adobe Firefly, Midjourney, ChatGPT to create content, whether that be visual or whether that be text. So can we maybe do a little bit of a temperature check about what's happening at the moment in terms of legalities of trying to figure out, actually, if you did use these tools to create content, where does the ownership lie really of that content?
Yeah, it's a really interesting one, actually, because our kind of main piece of law that deals with copyright, and I'm going to kind of focus on copyright because that's your primary IP right if you're talking about creating something.
Yeah.
It's from nearly 40 years ago. It was sort of introduced in 1988.
Gosh.
But when they did that, some very forward-thinking person did include provisions in there specifically with AI in mind.
Wow. Huh?
I mean, that is quite something from sort of, nearly 40 years ago. But the problem is, obviously, they didn't know how it was going to develop, what it was going to look like. So the language doesn't necessarily give us a definitive answer right now. So it is kind of going to be a wait and see on the interpretation. But I can kind of go through a bit of the outline of what the law is and where it could lead and where I think it's probably going to lead.
And we'll just say that for everybody listening, this is mainly UK, right? In terms of what you're about to discuss. Okay, go for it.
Yeah. So the kind of main thing we're talking about here is computer-generated works, which is what was introduced, well, part of what was introduced in the 1988 Act, a very small part of it, I should say. And those were works that were generated by a computer without human input, or authorship, I should say, not input. And they said that the owner of those works would be the person who made the arrangements for the work to be created. So right there, you've got an immediate problem, which is, well, who made those arrangements? On the face of it, your immediate reaction is probably the person who input the commands, who asked the questions of ChatGPT, Adobe Firefly, whatever it might be, to get that output. But equally, there is a pretty sensible argument that actually the arrangement was creating that software in the first place that allowed this to even happen.
That's what I was thinking. Yeah.
So you've got these two strands leading to very different outcomes. One where it's going to sort of lie with the creator of the software, and the other where it's going to lie with the person who's the user of the software. Mm-hmm. And the honest answer is we don't know which of those it will be. There's nothing in the legislation that guides you one way or another, and there's no case at the moment that's decided the point. My personal view is that it's probably more likely to be the user, for sort of almost like public policy reasons, I suppose, in that if you put it with the companies, these companies are going to have a vast control over massive amounts of created works. And your right to use those works that you have asked for is going to be contingent upon the goodwill of those companies saying, yes, you can. Now, there's a very sensible commercial argument, which is that no one's going to use this software if they then can't use the thing that it creates.
Yes, exactly.
But that seems to me to be the more logical scenario. And interestingly, actually, this is all somewhat superseded by the terms of use for the different bits of software. Now, I've only had a look at ChatGPT's at the moment, but they actually have in there right now that whatever you create, they will assign you to the extent they can the rights in it. So from a contractual standpoint, actually, they've done away with the decision. They've said, you know, whatever the law says, if we own it, we're assigning it to you.
Yeah.
So we kind of have an answer, but only dependent upon the terms of whatever it is you're using.
Now, I haven't used the visual ones like Midjourney and whatnot, but we know with ChatGPT, a lot of its learning was based on data. and content that's already out there, which is kind of why the question comes up, because if it's actually using content from other people, that gets a bit more complicated. Whereas I wonder with stuff where it is all about prompting, like with visuals, where it's almost just creating on screen what you're prompting, I don't know if there's a slightly different angle to that. I don't know.
Yeah, there's almost sort of two stages, and I kind of skipped over the first stage, I suppose, which is whether or not it's protectable in the first place.
Yeah.
And a lot of that will come down to whether or not it's original. And again, you've got competing ideas, which is, well, if it's based upon learning from all these other works, is it original? Is it not? The argument with that is that, well, whatever I create is probably at least in part informed by my learned experiences. You know, as long as you are not either consciously or subconsciously copying something, you may well have taken a bit of this, that, and the other into your mind and thinking, and it's allowed you to develop this, whatever it is, writing a book, let's say. My view is that it probably is protectable, largely based on the fact that when this legislation was put in place, they did build in these provisions specifically to deal with ownership of computer-generated works, which would suggest they are at least theoretically protectable. And then it's probably going to, a lot of it going to come down to the individual circumstances of the creation. So the fundamental test for originality, and that's one of the major cornerstones of whether or not it's protectable, is it a creation of intellectual effort from the author? Now,
sounds a little bit like the discussion we were having in our other episode about Ed Sheeran and his songwriting as well, isn't it?
Yeah.
Are we going to get to that point?
That's it, and it is a tricky one because it's quite a broad test, and it kind of cycles then back also to who was the author. If we're saying it has to be their intellectual creation, but at a base level, I think the more work someone has put into getting an output, the more likely it is a creation of intellectual effort, provided they're the author. Because if you just type in, I don't know, give me a nice picture of a sunset, arguably that's a lot less effort than create a Dali inspired image of a sunset going across a specific mountain range, and then maybe you refine it with some further commands. So I think it's going to be quite a nuanced point, but it's certainly, in my mind, it's at least possible that it's protectable, and then the ownership one is still probably the wide open.
Originality.
But, yeah.
I'd hate to be a judge in years to come, I have to say.
Yeah. We're already starting to see some cases trickle through, not
Really?
towards judgment or anything like that, but you've got Getty Images are suing one of the AI companies, Stability AI, over the use of their images to train the AI.
Oh. Do they not have to give permission? Do they not have to give permission for their data to be used for that purpose?
This is the interesting thing, and one of the points that's going to have to be decided at some point is it a fair use of the copyright to train these machines? And that's certainly an argument that's being run in the US. I'm not entirely sure what the argument being run in the UK is, but that's probably going to be the more likely scenario for cases in the near future, is big companies suing big companies over whether or not this is allowed. Because if they can cut it off at source from copying their works, then actually they don't have to go after individuals who have created a couple of images. It's a far more sensible.
It's a more sensible route. I mean, Getty's are so
to run.
Anal about their licensing and things like.
I
just don't see them. I don't see them liking that at all.
No.
So there's a little bit here that kind of leads into my second element of ownership, and this is a very grey area, right? So this is just going to be an open discussion between you and me, but having your likeness cloned, so whether that's through imagery, so we know about fake videos, fake imagery and that kind of thing, and also potentially voice. So I feel a little bit uneasy about this, but at the same time there is opportunity. But it did make me wonder when I heard, when the actor strike was going on, and they interviewed actually, no, I was following one of the actors on Instagram, and they were actually saying in a video on Instagram why it is that they were getting a little bit teased off of this. And I couldn't actually believe that the production houses or whoever owns their contracts as employees were wanting to clone them, so they'd have to go through this whole scanning process from head to toe to clone their whole visual likeness. But then the production studios wanted ownership of that likeness so that they could then use that in future without their permission.
Yeah.
So like part of me was like, hell no, because they don't get then paid for that work, and you're going to put another whole profession out of work.
This is it. I mean, it's already been, I think it was Drake. Someone trained some software based on his voice to produce a song.
Oh, jeez.
And it certainly made it into sort of the sort of Spotify and things like that. And there was some uncertainty whether or not it was his. And he took action, and it was taken down very quickly. But that's already out there.
Yeah.
And it's a very difficult one, because
What do you do?
it's not necessarily IP rights in terms of copyright and things like that if
No.
they're scanning you and creating your image, but then they're using your likeness, so that brings all sorts of elements into place. It's privacy, your right to a private life. If they go off and do whatever with that, is that a problem? There's elements of data protection in there.
Yeah.
Different jurisdictions have some quite different and peculiar rules. So in the US, you do have image rights, which is sort of your right to control the commercialization of your likeness, some sort of indice review. It might be your signature and things like that. So they do have laws in place to prevent you just being copied. But if you consented to it as part of a contract with a studio, then that may well do away with that. In the UK, we've got something called passing off, which is very broadly the right to prevent someone from misrepresenting a connection with you to sort of sell something.
Yeah.
And a good example, which is related to this, is the Rihanna and Topshop case. So she had an image of her put on a t-shirt by Topshop and sold. She didn't endorse the t-shirt, she didn't design the t-shirt. Topshop did have a license to use the photograph of her. It was from one of her albums, so they had a license to do that from the photographer, so they were in the clear on that front. But she was saying that, well, no, you're creating this idea that I've endorsed this product. And she did win that case, although it's worth saying that there were some other factors in play as well, that she did have a tie-in with Topshop to do some competition, I believe, where you got to do a personal shopping experience with her in London. She'd had other sort of dealings with them in the past, so there was a greater likelihood that the public would be deceived into going, oh, that's Rihanna's top she's designed that, I want it for that reason. So there are more factors at play in that, but we do have some laws to help with that. And I certainly think for your average person, not necessarily your celebrities, the right to privacy is a big one, because you and I would not expect some company to be able to create a likeness of us for some whatever purpose that might be. It's beyond the realms of what anyone would expect as an ordinary citizen.
And I know we're busy investigating. This might lead on to something else I wanted to talk about a little bit today. With can we protect ourselves a bit more in some T's and C's and contract terms? But we're busy investigating with our agency the idea of cloning your voice for podcasts. So if somebody is not necessarily comfortable in front of the camera or the mic, they could actually get their voice cloned professionally in a studio, and then you could write your podcast in the words and then we get the cloned voice to actually read it out as your audio for your podcast. So I would think from that perspective, us as an agency then, in terms of our T's and C's, we'd have to put some kind of, and we would do, because we're only investigating at this point, because I'm getting a little bit freaked out by this whole thing, but it's something to think about, because we do have some clients who they just don't have the time to do all of the steps to the production as well. So it might well be something good. But do you then, like you said, do you treat that a lot of like we do at the moment in terms of data protection? I get really specific about the use of the voice, and only by permission and only for a length of time. And once the client leaves, that data gets deleted. And, would that help, do you think, for that kind of scenario?
I think so. I think if you were clear about the consent and what it was being used for, it's probably much less likely you'd ever have a practical problem, because as long as you stick to what's been agreed that you'll do, the chances of anyone having an issue with it's pretty slim. It's going to be more the kind of Wild West scenario of people taking clones off to do something else because they have this brilliant idea. They didn't agree it, but it's a great idea. It'll be fantastic, so we're just going to do it. It's been well known to happen, not necessarily in this field, but people use data for things they shouldn't really, because it isn't usually nefarious. It's just not well thought through, or they haven't considered the ramifications, and they're just steaming ahead with some new commercial idea they've got. And you've also then potentially bringing back in the IP element. If you are training it on, maybe not so much if they come in and specifically give their voice and sort of talk down a microphone to help train it, but the Drake example, that was, I believe, trained on his existing songs, which would be copyright protected. So that's, and then this brings us all the way back to the whole idea of, whether there's an infringement by training something. But it's, I think that would be the big thing, is having terms and conditions that make clear what you're going to do, how you're going to do it, how long you're going to keep it for, and whether or not you're going to have some sort of mechanism to go away and get further consent if you want to do something a bit different.
Yeah. So if we think about our listeners, service-based professionals, more than likely experts in their fields, a lot of their inherent value is in their knowledge and their reputation. So is there anything else that we could do to further protect our likeness if this does become a thing? Or do you think that's about all we could do, is think about terms and conditions? And
yeah, I think it'll be difficult to protect your likeness from people who just want to go off and copy you.
Yeah.
I mean, we already see it in other fields.
They're going to do it anyway.
You can have copyright notices. Yeah, people, you know, we have a criminal justice system because people will ignore the rules when it suits them. But certainly things like knowing that you have got rights, you can, you know, taking early steps. If you see this has happened, is getting in touch to make very, very clear that you don't consent, you've never consented, and you object vociferously to that action. There's other things you can do in the background, kind of, it's not really protecting your likeness, but protecting your brand and the reputation. So consider whether or not trademarks over your key course identifiers, brand identifiers, your, you know, how you are putting out your knowledge. So if you call it a specific thing, consider whether or not you want to trademark that. So even if they copy your likeness, you've then got a second element of, if they copy that protected trademark, then you've got another string to your bow to go and take action. But it is going to be relatively hard if someone is determined to, you know, you see it at the moment with deep fakes and things like that. Unfortunately, people will do some things that they shouldn't regardless.
And do we do extra copyright notices, do you think? Maybe watermarks in our video content, or, you know, you see a lot more nowadays with LinkedIn, people are putting little notifications at the bottom of their posts. You know, would those little bits and pieces help, or is it just more to just, you know, kind of almost show that you wouldn't frown quite seriously upon anybody messing with your content?
I think it's always a good idea. Certainly the kind of copyright notices, depending on the jurisdiction, some jurisdictions say that's necessary, others say, you know, you should do it, but it's not going to prevent you from bringing a claim. And it's like you say, it's telling people, this is mine, I will protect it if I need to. Watermarks are useful. You know, lots of photographers do that to stop people just going on Google and finding an image they like and making free use of it. You've also got more technical things that are coming out. And I'm not going to pretend to have sort of detailed background.
No, but you'll know more than me on this.
But I think there are people who are working on bits of code that you can put into the background of your images, for example, so that if they try to train the software on them, it distorts and it just doesn't work.
Nice.
So I would imagine there's going to be a growing market for that sort of thing, that you can embed whatever it is into the background of your video, your image.
The metadata or something.
Yeah. However it will work, that will then help prevent people from training their software on your content that's available online.
Oh, it's a lot of things to think about, eh? But I have a positive example. I don't know if you've ever heard of Jodie Cook, and I do need to reach out and see if she'd possibly come on the show. But she created a tool called 𝗘𝗣𝗜𝗦𝗘𝗟𝗟, and it's basically a virtual coach that you create of yourself, but it's a closed platform. So when you actually train the AI to build a coach that's a duplicate of you, a clone of you, but it's trained on all of your content. So I think you have your own space in which to do that, and your coach is trained on it. And the idea is you can almost add different offers really to your coaching thing. So if you got someone who came up with a bright idea at midnight, they could go and talk to your coach, your clone coach, not you, thank God. But they could have really sensible conversations with them because, you know, it's been trained on, and obviously you have to have a body of content in order to train your coach. But I don't think I mind that, as long as it's almost in a closed environment where all the permissions and the data protection is very clear. What do you think about that?
Yeah, I think that's right. I think there's a lot of sort of naysaying and doomsday type talk around AI, but it has got a lot of massive positives to it. So that's something that could improve the efficiency of the business. It can improve availability, freeing up more of your own time. I mean, I saw an article this morning about a piece of AI software that was being trained and used to help detect cancer, and it had picked up this woman's cancer when the human viewer of her scans missed it. So she was able to have it removed very, very early. I think it said something like, a couple of weeks of radiotherapy or something, and she was in the clear. And, and this software had just picked it up when the human had missed it, and otherwise it might have not been picked up for another, however long. Who knows? It could have been a far more. So it's got some huge positives, and it could be a real massive benefit. It's just going to be very much, and I'm glad I don't have to be working out how it's going to be regulated and used and dealt with, but I think that is going to be important, just making sure it's not allowed to run amok, so to speak, but is allowed to do some really good things for society.
Yeah, I just hope that whoever gets to decide things, it is for the common good of humanity. Because there's not a lot of that going on in the political realm at the moment, so that is a little bit worrying. Oh gosh, well, thank you so much for today, Stephen. I think everybody listening would have grabbed at least one takeaway, and I think if anything, it's we can't ignore what's here and what's coming, can we really?
Yeah, it is coming whether we like it or not, I think, is the answer. So work out how best we're going to deal with it.
Yeah. So Stephen, if anybody wanted to reach out and contact you about protecting the IP, or just like cry over a cup of tea over the AI, no, people, he's not free for those kinds of meetings. How can they get in touch with you?
Easiest way is usually just to email me, stephen.ruse@𝗧𝗛𝗜𝗦𝗛𝗟𝗟𝗟, or you can find my contact details through the firm's website. More than happy to speak to people if they want to have an initial chat about any issues.
And you're on LinkedIn as well, and I'll drop all of those links in the show notes as well. Okay, so thank you so much for joining me and sharing your knowledge as always, Stephen. You explain and really describe complicated concepts in a really palatable and relatable way, so thank you so much.
You're welcome. Well, thank you for having me on.
And that's it for this episode today, folks. Thank you so much for joining us. Did that help you to realise that our world is changing pretty drastically and that we can't really ignore the progress of artificial intelligence? While today's conversation did lean towards protecting yourself, just remember that there are also huge advantages to AI, and we'd all really be silly not to pay attention to those too. Do you have any more questions about AI in your business? Let me know. Maybe I could get somebody else on to come and walk it through with us. Who do you know that could do with hearing Stephen's insights? Share this episode. You know you want to. Until next time, stay strong, believe you have value, and make good brand decisions.
Thank you for listening to The Brand Compass. If you enjoyed this episode, make sure to share it with your entrepreneurial friends and help them make good brand decisions. Until next time, let's keep the conversation going at 𝗘𝗣𝗜𝗦𝗘𝗟𝗟𝗟.com.